This new case from North Carolina Court of Appeals involves what can be described as a cover-up of medical malpractice, and at the very least is a story about physicians who are willing to look the other way as one of their own mistreated children. Yet despite that horrific story, the appellate decision itself turns on a procedural issue that threatens to bar the plaintiff's claims entirely. Let's talk about it. Let's start by going through the facts. The plaintiff in this case is Brittany Cottle and her two parents. The defendants are a number of orthopedic providers, primarily a physician named Dr. Keith Mankin at the Raleigh Orthopedic Clinic, and then a bunch of other individuals that were affiliated with his practice. The order that's being appealed in this case is a summary judgment order that was entered on March 16th of 2022. The case wasn't heard in the Court of Appeals until January of 2023, and it is now May of 2024. And so it was over a year from the argument in the Court of Appeals to this written decision, and it's been over 2 years since the case was originally dismissed. It was initially filed all the way back in 2019. And so this just goes to show you how long these cases can be pending. And this case is not arriving at a resolution yet. It is still going to be ongoing from here on. According to the complaint, as far back as 2003, other pediatric orthopedic surgeons in the Raleigh area began to see Dr. Mankin's patients for second opinions after Dr. Mankin recommended surgery for these patients. These other surgeons, in doing their review, concluded that surgeries were completely unnecessary, and they began to be concerned that Dr. Mankin was recommending and performing completely unnecessary surgeries on children. It got to the point where at least one outside physician, as well as the parent of one of Dr. Mankin's former patients, raised this concern with leadership at Raleigh Orthopedic Clinic, and according to them, were basically blown off. The clinic didn't do anything. What we know is that Dr. Mankin continued to practice at the Raleigh Orthopedic Clinic, including in 2010, when the plaintiff, Brittany Cottle, came to him for care relating to back pain. As was apparently his practice, Dr. Mankin recommended surgery. And that surgery took place on October 4th of 2010. But it's not exactly clear what surgery Dr. Mankin performed. His operative note says that he performed a spinal fusion, but according to a subsequent physician, there's little evidence that such a surgery was performed, and if a fusion was performed, it was performed so inadequately that there was no evidence remaining that it had ever occurred. About that same time, Dr. Mankin performed another spinal fusion on another pediatric patient. That patient then went and saw an outside orthopedic surgeon following the surgery, and that surgeon apparently told the patient and his or her parents that the fusion was completely unnecessary and was not properly performed if it was performed at all. That patient's parent then contacted the leadership at the Raleigh Orthopedic Clinic, again raising concerns about Dr. Mankin's care. And again, nothing happened. Around this time, a new physician joined Raleigh Orthopedic Clinic, working as a junior associate with Dr. Mankin, and that is Dr. Neil Venning. We have an affidavit from Dr. Venning, which is really important. According to his affidavit, shortly after joining the practice working under Dr. Mankin, he quickly learned that Dr. Mankin was generally known in the local pediatric orthopedic community as a problem physician. According to him, other nurses came up to him and said, "You have got to do something about Dr. Mankin in these surgeries." Dr. Venning said that he found case after case where Dr. Mankin appeared to make up surgical indications, misrepresented MRI and X-ray results, made unsupported diagnoses, and generally provided incompetent medical care to his patients. Dr. Venning ended up taking over the care for one of Dr. Mankin's pediatric patients when Dr. Mankin went on vacation. And according to Dr. Venning, immediately upon reviewing the child's chart, it became obvious to him that Mankin had performed surgery in a completely unacceptable manner. To his credit, Dr. Venning took this case and brought it to the attention in a meeting in late 2011 or early 2012 with the executive director of the Raleigh Orthopedic Clinic, one of the other partner physicians in the clinic, as well as a representative of their medical malpractice provider. He presented this case and argued that Dr. Mankin was a danger to his patients. According to Dr. Vinning, at that meeting, the malpractice representative said, "Let's offer a settlement to this family." And I have no idea if that happened. The other physician in the room said we need to fire or release Dr. Mankin. But that didn't happen. Even following that meeting, the warning from Dr. Vinning, Dr. Mankin continued to practice with the Raleigh Orthopedic Clinic. On March 29, 2012, an outside physician sent an email to one of the orthopedic surgeons at Raleigh Orthopedic Clinic where he said that the local pediatric orthopedic community has concerns with Dr. Mankin. And he says that he's seen many problematic results and decisions from Mankin, and he wants to see if there's a way to, quote, minimize the damage without having to go to the medical board. And this is an interesting theme to this case, and I'll try not to be on my soapbox too long. But all of these physicians, or I guess I should say many of these physicians, are well aware that Dr. Mankin is performing unnecessary surgeries and botching them on children as far back as 2003, and yet as far as I can tell, no one is going to the medical board. They are all trying to resolve it without involving the medical board, which is there to ensure safe patient care. And yet no one wants to do that. Despite this, Dr. Mankin was still working at the Raleigh Orthopedic Clinic and was still performing surgeries on children, including Brittany. In November of 2012, Brittany's back pain has returned, and she comes back to the Raleigh Orthopedic Clinic and Dr. Mankin, completely unaware of all that is happening in the background. And Dr. Mankin does what Dr. Mankin does, which is he recommends surgery. And so she has another surgery in November of 2012. Imaging taken at the time of the surgery shows that 2 of the 3 screws that were placed in this child's body were completely misplaced. That should have been obvious at the time that the surgery was performed, and according to one physician, should have been fixed intraoperatively, meaning during that surgery. And yet it wasn't. That here happened, and Brittany was again released out the door, still not aware of what has been happening to her. In January of 2013, a number of outside pediatric physicians get together to draft a letter to Wake Med Hospital, which is where Dr. Mankin was performing his surgeries. And they warn Wake Med that Dr. Mankin has a pattern of incompetent and even dangerous care. They warn that Dr. Mankin presents a very real danger to his patients. But even in this letter, again, they reference the risk of litigation and their desire not to go to the medical board. They want Wake Med to review Mankin's surgeries and to revoke his credentials without involving the medical board, which would create a public record. You know, and I catch grief from medical providers all the time because I represent victims of malpractice. And then I read a case like this and think that they have no ground to stand on, where you have apparently every pediatric orthopedist in Raleigh knew about this guy all the way back to 2003, and yet here we are in 2013 and no one wants to go to the medical board about it. This guy is performing surgeries on children and botching them. He's been doing it for a decade. Everybody apparently knows, but no one wants to go tell the medical board, and then they turn around and look at the malpractice lawyers like we're the problem. This letter gets sent to Raleigh Ortho. I don't know if it ever got sent to Wake Med, but it gets to Raleigh Ortho, and that is finally what triggers Raleigh Orthopedic to do an investigation called a peer review of Dr. Mankin's performance. Following that peer review process, Dr. Mankin agrees to voluntarily resign. So he leaves Raleigh Ortho and he goes and he starts his own practice. And at this point, Dr. Vinning has had it. He sends a letter to the medical board where he raises his concerns. He tells this story about Dr. Mankin's care, everything he's learned, and he asks the medical board to take action. And I just want to say that I've met a few of these types of providers in my time, and it is always refreshing to see them. People who have character and integrity and are willing to stand up for patients that aren't even theirs because it's what's right to do. And in the case of Dr. Vinning, to have done it initially towards a partner at his practice when he was just an associate. That takes some real courage, and I really commend him for that. The medical board does an investigation, and they enter into what's called a non-disciplinary consent order. So it's an agreement between the medical board and Dr. Mankin. It's not disciplinary. It's not an adverse action. He doesn't, quote, lose his license. But basically, he agrees he's not going to practice medicine in North Carolina any longer. I think he's now an author down in Texas. With all that happening, remember, Brittany is a victim of medical malpractice at least once, probably twice, and doesn't know it yet. And so in 2016, when her back pain returns, she comes back to the Raleigh Orthopedic Clinic and learns that Dr. Mankin's no longer there. Instead, she sees a different physician, and this other physician was involved in that peer review process that resulted in Dr. Mankin's ouster. So he knows about all of Dr. Mankin's problems. But in his 2 appointments with Brittany, he never tells her about Dr. Mankin. He doesn't tell her that the screws in her hips are completely ineffective. He doesn't tell her that her spinal fusion was flawed, if it occurred at all. He doesn't tell her that Mankin has been asked to resign. He doesn't tell her that Mankin it can't even practice medicine in North Carolina any longer. He doesn't tell her any of that. Well, Brittany goes to see another physician at another practice who finally tells her the truth. He tells her that she never had spinal stenosis, that there was little evidence a fusion had ever been performed, that she didn't need a fusion, and that 2 of the 3 screws that had been placed weren't placed properly. That conversation happens in November of 2016. And here's the problem. Dr. Mankin's last surgery was in November of 2012. And for medical malpractice actions in North Carolina, the statute of repose, a limitation in terms of how long you have to bring a medical malpractice lawsuit, is 4 years after the last negligent act by the physician. And so her time, the statute of repose, is quickly running out, if not gone already. So Brittany files a lawsuit, and motions are filed to grant summary judgment on the basis of the statute of repose, and those motions are granted, and that leads to this appeal. The first argument involves claims against individuals who knew that Dr. Mankin had been performing unnecessary surgeries on pediatric patients. And basically the plaintiff says that those people had a duty to warn Brittany and to disclose to her that Dr. Mankin had been doing this, and that their failure to do so was a tort against her, basically fraud. The Court of Appeals says no, and doesn't spend a lot of time on it, just says no, basically because those people didn't know that that was happening to Brittany. So they didn't know what Dr. Mankin's care was going to be for Brittany. They didn't know what Dr. Mankin's surgeries were going to be for Brittany. And since they didn't know any of that, they didn't have any duty to her. Their general knowledge of Dr. Mankin's reputation doesn't give rise to a duty on their part to then reach out affirmatively and warn Brittany, a patient who they don't really know exists specifically. The next argument is that the doctors that saw her at her follow-up appointments in 2016, after Dr. Mankin had already left, that they had a duty to disclose to her what all had happened, and that they didn't. And the Court of Appeals doesn't really address whether or not that their failure to share all that information was negligence. What they say is that even if it was, it didn't cause a new injury. Brittany's injuries were caused by Dr. Mankin's first 2 surgeries. And so the failure to disclose in 2016 didn't cause any new additional harm, even though it may have been upsetting. It didn't actually cause any injury, and so there can't be any claim against them. Finally, they turn to the last issue, which is the statute of repose. And basically what the plaintiff argues is that the statute of repose, which puts a time limit on bringing medical malpractice claims, does not apply to the claim against the Raleigh Orthopedic Clinic. that they're making a claim against Raleigh Orthopedic Clinic directly, and the basis of that claim is what's called negligent hiring and retention. Basically, Raleigh Orthopedic Clinic should have known, and in fact knew, that Dr. Mankin was performing unnecessary surgeries, that he wasn't competent, and that they should not have continued to employ him. And that since they continued to employ him, Brittany was therefore cared for by him and harmed as a result. And it's a direct claim against the Raleigh Orthopedic Clinic. The Court of Appeals agrees and says that that claim is not barred by the statute of repose. Here's how they get there. The statute of repose is a carve-out. It's a law for medical professionals, and it puts that 4-year time limit. Well, our statutes also define what is a medical malpractice action. And a medical malpractice action is defined as a civil action for damages for personal injury or death arising out of the furnishing or failure to furnish professional services by a healthcare provider. So what is a healthcare provider? Well, the statute defines a healthcare provider. And the only non-human being healthcare providers, like the only institutions that can be healthcare providers under the statute, are hospitals, adult care facilities, or nursing homes. And the Raleigh Orthopedic Clinic isn't any of those 3 things. It's not a healthcare provider. And since it's not a healthcare provider, it's not covered by the medical malpractice statute. And since it's not covered by the medical malpractice statute, the claims against it are not for medical malpractice. And since the claims against the Raleigh Orthopedic Clinic are not for medical malpractice, the statute of repose, which would bar that claim, doesn't apply. And therefore the case gets to survive. And that, I would say, is the takeaway for the lawyers watching this, is that a negligent hiring and retention claim by a non-hospital, non-adult care facility, non-nursing home, that claim is not a medical malpractice claim and survives the statute of repose. So Brittany is left with one claim surviving, that negligent hiring and retention claim against the Raleigh Orthopedic Clinic. And I have to say, I suspect that if this case were to go before a jury, even on that claim in Wake County, I think Brittany would do very well before a jury with these facts. They're just so egregious, they're so unacceptable. And at the heart of it is the misconduct by the Raleigh Orthopedic Clinic, in addition, of course, to Dr. Mankin. Either party could appeal this decision. You could see a situation where the plaintiff wants to appeal the dismissal of all of their other claims, particularly because the Court of Appeals didn't spend much time discussing them. And you could also see, of course, the defendant, the Raleigh Orthopedic Clinic, want to appeal this decision. The Supreme Court right now is pretty favorable to medical providers, so I could see the defense wanting to try their luck there and maybe make some law that's good for them and ultimately bad for patients and bad for victims. So I hope you found this informative or helpful. If you did, please let me know. Encourage me to keep making them. In the meantime, if there's anything else I can do for you, don't hesitate to reach out.